stand up for you.
Nobody. Oh,
All rise. The Honorable Court of Appeals for the 7th District of Texas session. Please be seated. We have 2 cases set on the docket this afternoon. And is anyone here on the second case other than Mr. Johnson? Okay, I'll call that one after, we'll take a brief recess after the first case and then we'll call your case. The court will call, let's see, 2 appeals and 1 original proceeding. Cause 0724-309-CV in the matter of the guardianship of Kenneth Gregg, an incapacitated person. Cause number 07-25-35-CV in re Monty Gregg, individually and as trustee of the Kenneth Gregg Trust, relator. And cause number 07-25-36-CV in the matter of the guardianship of the person and estate of Kenneth Gregg. What says the appellant and relator?
Appellant and relator is present ready.
Okay, and who will be arguing?
I will, Heidi Block.
Okay, thank you. You'll have 20 minutes with a 5-minute rebuttal. And then for appellee.
Remind your colleague. Rise, I'll be arguing.
Thank you. Ms. Block? Yeah.
May it please the court. Good afternoon, Heidi Block, and along with my co-counsel, Ben Garcia, we are here on behalf of the appellant, Monty Gregg, and with multiple parties with the same last name. I'll be referring to my client as Monty, who is sitting in the courtroom. And Kenneth Gregg, the ward, I'll be referring to him as Kenneth, and appellee Lucretia Howe, I'll be referring to her as Howe. So as the court noted, I have 3 proceedings to talk to you about in my short time with you this afternoon. I certainly want to answer any questions the court has on any of the matters, but my intention is to spend just a little bit of time on the primary, the first appeal, the guardianship order appeal. a little bit of time at the end on the mandamus if I still have time. And I do intend to spend most of my time on the temporary injunction. But again, it's a free-for-all, so ask questions about any of it. First, on the guardianship appeal, we've raised 3 issues. I urge you to focus on the one that involves the statutory requirement that the trial court shall give due consideration to the preference indicated by the proposed ward. And that's found in the Estate Code 1104.002. And specifically, I urge you, although you probably already have, read the almost 70 pages of testimony given by Kenneth in the underlying guardianship proceeding. He spent some time on the stand. He was questioned by 3 different attorneys. This is on the last day of the hearing. And when you read that testimony, it's clear that, well, Kenneth gets some words mixed up on occasion. He knew exactly what was going on. He knew it was a guardianship proceeding. He knew there were competing applications from his son Monty and his daughter, well, both daughters, Charlotte Gregg and Lucretia Howe.
Why do you think that, or why is it your position that the court didn't give due notice of that?
Primarily, Judge, because it's nowhere in the guardianship order that the trial court signed.
Well, is there a requirement that it has to be in the order?
The statutory requirement is simply that the trial court give due consideration.
Right.
But I submit to you that in the trial court, I think importantly, the trial court entered findings of fact in this case. And yet there's no mention of Kenneth's expressed preference in the findings of fact. And so I submit to you that that's an indication of just the opposite of what the statute requires, that the trial court didn't give due consideration, or else at least we would have had some mention of it in the findings of fact.
Do we have ordinary standards for legal and factual sufficiency like we would in other civil cases on assessing the evidence and the discretion the trial court has?
You do, in the sense that the standard in a guardianship order, the standard of review is abuse of discretion. And it is an abuse of discretion for the trial court not to follow the law. And so I think this is an evidence of that the statute requires that the trial court give due consideration. We don't see it anywhere in the record, in the order, or in the findings. And so we do ask for a remand, a reversal and remand on that issue.
Are there any presumptions? I know it's not in the finding of facts that he gave due consideration. Are there any presumptions, though, that he did follow the law versus not following in absence of intervention of it?
To be fair, I think, we always have to presume that judges follow the law. But again, when you look at the findings and consider this, if you look at Kenneth's testimony, he was very clear about what he wanted and didn't want. He knew what was going on. He knew who his 4 children were. He several times expressed a preference for Monty to be his guardian. And not only that, but he expressly told the trial judge that he was not happy with how Howe was handling his estate while she was the temporary guardian.
Wasn't there testimony perhaps that Monty would be disqualified to serve as guardian because he owed or had not repaid a $15,000 loan?
I don't remember the particulars about that testimony, Judge. I apologize, but I don't think that's a statutorily disqualifying factor. I may have a better answer from you on rebuttal on that, as Mr. Garcia was the one who tried that case and is more familiar with the facts. If I may turn to the temporary injunction appeal. Now, at the outset, it's important to keep in mind there are 2 distinct sets of conveyances at issue here. The 2023 conveyances that occurred in June and October of 2023, where Kenneth conveyed to Monty individually ranch property and cattle on 2 different occasions, all in 2023, that occurred before any guardianship action was filed. So that's the first set of conveyances. The second set all occurred on one day, July 16th of 2024. And that was after Howe was appointed temporary guardian, before she was appointed permanent guardian. And it occurred actually during the guardianship hearing. the day before the last day of the hearing. And the timing distinction is important because Howe's primary argument to this court and to the trial court has been that Kenneth's conveyances to Monty, or his conveyance in July of 2024 to the trust and his appointment of Monty as trustee of his trust property, their theory is that all those conveyances were somehow invalid as a matter of law because a guardianship action was pending. Now, of course, that argument doesn't even apply to the 2023 conveyances of ranch property and cattle because there was no guardianship proceeding commenced at the time. But with respect to the July 16th, 2024 conveyances, and again, there's a package of July 16th documents. There's the trust that Kenneth Gregg created. There's an assignment by Kenneth of all of his remaining real and personal property to the trust. He also had a pour over will, and then he appointed Monty as the trustee of his trust. Howe's argument that all of those July 16th documents are invalid as a matter of law fails. It is wrong under the common law. It is wrong under the estate code statutes, and it is wrong under the language of the temporary guardianship order itself. So here's the key. On July 16th, when Kenneth Gregg signed all of those documents, he had the personal right to do so. He had the right to dictate how his possessions would be dispersed, distributed, preserved in a trust. He had that right. He had that right under the common law and under the statutes, and there's nothing in the temporary guardianship order that stripped him of those rights. So under the common law, we have the Weatherly versus Bird case that I've cited in, that we've cited in our reply brief. That is a Texas Supreme Court case from 1978 that focuses on the importance of a ward retaining his or her personal rights, such as in that case, it was revoking a trust. And the court even analogized it to creating a will, trust and a will. Those are personal decisions that a person has the right to make. And the fact that there's a guardianship, that the ward is under a guardianship, doesn't necessarily strip the ward of those important personal rights.
The Supreme Court had an opinion that got issued Friday of last week that
In Ray Benavides.
That's right. That involved marriage issues. I know they didn't reach the ultimate issue that we're talking about here. Does
Right.
that opinion shed light any on it?
Absolutely. Again, and you're right, it's not on point, but it's the In Ray Benavides case, which is, it was issued on April 25th, case number 23-0463. And that case involved whether or not a guardian could pursue and maintain a divorce action. So not our precise issue, certainly. But in that case, the court talks about the importance of retaining a ward's personal civil rights, unless those rights are specifically, and I use that word emphatically because it's in the statutes, and I'll get to that in a minute, unless you have an order that specifically strips those rights away by specifically granting those rights to the guardian. And we don't have that here. So you've got the Weatherly case, the recent In Ray Benavides case, two cases from the Supreme Court talking about the importance of maintaining a ward's civil rights. And you can only strip those rights away if it's specifically granted in the order. And before I get to the order, let's look at the Estates Code, because that speaks to that as well. The Estates Code codifies those important civil rights protections that the Supreme Court has talked about in Weatherly and In Ray Benavides. And in my oral argument exhibits, first of all, I've got a chronology that's certainly not intended to include everything, every important event, because it would be 10 pages long, but I tried to kind of list out the key events, partly for me, so I could keep track of what happened when. But then the second part is some of the relevant provisions from the Estates Code. So what we have first, we have section 1251.002 that prohibits a presumption of incapacity during a temporary guardianship. And all that was in place on July 16th, 2024 was a temporary guardianship. So there can be no presumption of incapacity. And that didn't happen until the judge several months later signed the permanent guardianship order, where the judge actually found that Kenneth was incapacitated. Second statutory provision that I think is important here is that even in a permanent guardianship, the ward has been guaranteed by the legislature a Bill of Rights. And those rights include the right to exercise full control of all aspects of life not specifically granted by the court to the guardian. There's that word specifically again. And this is an important one. The ward has been guaranteed the right by the legislature to self-determination in the substantial maintenance, disposition, and management of real and personal property. So Kenneth Gregg had those rights on July 16th when he signed those documents. And then third, we've got the statute 1151.001 that says, again, even a fully incapacitated person under a permanent guardianship retains all legal and civil rights and powers, except those designated by court order as legal disabilities by virtue of having been specifically granted to the guardian. So let's look at the temporary guardianship order. And excuse me, that's not. We have to look to the temporary guardianship order to see if there's anything in there that specifically stripped Kenneth of the rights that I've been talking about by specifically granting them to the guardian. And there is none. There are no such provisions in the temporary guardianship order. There's nothing in that order that strips Kenneth of those rights. There's nothing in that order that specifically grants to Hal as his guardian, the guardian of his estate, or to Charlotte Gregg, the guardian of his person, the rights to dispose of his property, the right to manage his property, the right to start a trust, establish a trust, doesn't grant her the right to assign his property to the trust. So because the court didn't specifically grant those rights to Hal, the common law and the statutes both say Kenneth still retained those rights. So her primary argument that the documents are somehow invalid as a matter of law is just wrong. So to sum up, so far, we submit that neither the 2023 conveyances nor the 2024 conveyances are invalid as a matter of law, which is what Hal contends. And then the July 16th, 2024 documents cannot be part of any injunctive relief because neither Monty as trustee nor the trust were parties to the suit. And that's one of the other fatal defects of Hal's argument regarding and the temporary injunction regarding the July 16th documents. And again, those documents created a trust, assigned all of Kenneth's remaining property to the trust. So that property is trust property. It is no longer Kenneth's property. It is trust property. And Kenneth appointed Monty as trustee. So the only way to have injunctive relief that prevents Monty from acting as trustee or doing anything with respect to that property would be if she had sued Monty in that capacity, and she chose not to. So because Monty, in his capacity as a trustee, was not a party to the suit, there can't be injunctive relief against him in that capacity.
If there had been a suit in his capacity as trustee, would that be properly brought in the probate court or in the district court, which normally has jurisdiction over trust?
Yeah, that's a good question that came to my mind the other day, and I didn't look it up, so I don't have an answer for you. We're not there, so I don't know. But I do know that the estate code does have a specific provision authorizing a guardian to bring an action, bring a new lawsuit.
Well,
To
it certainly
cover
they
property.
do, and it should have been brought in this case, perhaps as an adverse action, not in the guardianship,
But
but
in the district court.
well,
it could
no,
be.
I think what's been filed could have properly been brought as an adverse action or an ancillary action to the probate, but not in the
Original guardianship proceeding.
yes.
Yeah.
Because obviously the code provides for guardians to collect claims
Correct.
and administer the
And
guardian
recover
estate.
property.
Right, and yes,
Yeah, and I mean, that's one of those many strange procedural things about this case. I mean,
well, that can be remedied though by
Yeah.
severance.
could
of-
be, yeah,
Of the
yeah,
action,
yeah.
right?
I think so,
And
yeah,
new cause number.
yeah. And, you know, she's free in that new case to assert a claim against Monty as trustee. I mean, that, you know, that she's the scrivener of her own lawsuit and she can sue whoever she wants. But the fact is she didn't sue Monty in his capacity as trustee. And so the court cannot order relief against Monty in his capacity as trustee. And Monty does not have possession or control of any of Kenneth's property other than in his capacity as trustee, because he's the trustee of the trust. I want to move to the undue influence argument because,
Well, let me ask
Yeah,
you one
you
thing real
bet.
quick. If the temporary injunction is eventually dissolved, does Monty have any recourse against the guardianship bond?
no, not as it exists. The guardianship bond that the court ordered is, I'm sorry, the guardianship bond is in place, but it protects,
The actions of the guardian?
yeah. And well, it protects against
Against
malfeasance of the
actions
guardian,
of the
but it
guardian.
protects the guardianship estate and actually the court. So there's no way that Monty could go against that bond. Again, you know, one of the other things that's wrong with the temporary injunction, but I certainly do urge the court to address the merits of the temporary injunction. Otherwise, we'll just be right back up here. On the undue influence, and I'm running out of time, but Howe must have presented some evidence that Monty exerted such influence over Kenneth as to subvert his will. And there's just no evidence
But
of that.
isn't that an issue for the final trial?
Ultimately, yes. And this court doesn't address the merits at this point, but the court has to examine whether or not, for temporary injunction purposes, the applicant, Ms. Howe, met her burden to show a probable right of recovery. And we submit that she didn't. We have direct evidence that supports absolutely no undue influence at all. We have disinterested witnesses who testified that, you know, this was Kenneth's idea to give Monty this property and to have him assume the debt. That's with respect to the 2023 conveyances. The July 16th documents, those were drawn up by Nathan Ziegler, a prominent estate planning attorney in town. And there were witnesses who signed, I think it was the pour over will. The witnesses averred in their witness statement that they believed him to be of sound mind.
Well, can
So-
the part of that be remedied by striking portions of the return order that pertain to the 2023 transactions or the injunction that covers those?
Well,
And then maintain the
yes.
status quo of the property that was in existence at the time the guardianship was created?
Well, when
and
you say at
maintain
the
it.
time the guardianship was created, there's the temporary guardianship,
Right.
and then there are the July 16th documents, and then there's the permanent guardianship. And I mean, this court does have the authority to, you know, line veto both of those, the orders that are at issue here. But I submit to you that, you know, the very most that could be upheld is to possibly enjoin Monty from selling the property that Ms. Howe contends was gifted to him through the exercise of undue
But that would
influence.
be to enjoin him individually and not as a
Right.
trustee.
Well, because he's not a party as trustee, yeah. But, you know, he's already testified at the hearing that he has no intention of selling the property, so there's no imminent harm. But I think at the very worst, at the most, that's how narrow the temporary injunction could possibly be, is to just enjoin him from selling the real property that he got. I'm out of time.
Okay, any other questions? Thank you. Mr. McCollum?
Hello, and may it please the court. I'm going to hit on a few things that were raised just to kind of, I think, knock them out of the way.
Well, let me ask you this.
go ahead.
Is it customary for a temporary guardianship? The code requires that it after filing that no earlier than the Monday following the expiration of 10 days that the court take action on a temporary guardianship. Is this guardianship order void? Because according to the timeline, it was filed on December the 15th and Judge Parrish signed a temporary guardianship order on December the 22nd. And that's not 10 days.
I don't,
The first Monday after 10 days.
I think that the court has the control of when the order signed, and everything was presented, it was given to us, and taking action on that. The court took action after the hearing when he made his ruling.
Well, I know the application was filed on December the 15th and he signed the order on the 22nd.
But the action that, and I think maybe the argument is the action that was taken was the ruling that the court had made, which was at the hearing. And the memorialization of that action by signing the order just memorializes the action that had already occurred.
When was the hearing?
Hearing was on December 23rd.
But the court may not act on an application for the creation of a guardianship.
So the action was taken. There was action taken by the court. The court granted the temporary guardianship, appointed the temporary guardian, laid out what those conditions were. All of that was done at the time that it was at the hearing.
So your argument, I guess, is that on the 18th, there was an oral rendition?
There was an oral ruling on the application for temporary guardianship.
Well, that would, on the 18th, that would be even, that'd be,
Let me pull up
that'd be
the,
3 days notice.
what's that?
That would be 3 days notice. Specifically referencing section 1051.106.
I was going to get the,
And I guess similar question, I mean, Judge Parrish is the county judge, so this was not a court of record, right?
there's no court of record, but he still made his ruling.
How do we know what the ruling was if we don't have a record?
And that is all I can go off of what the court ruled.
Yeah.
And the court was presented an order when the court took the action. So if there's a technical issue there,
Well, I mean, if the temporary guardianship order wasn't a valid order, then you're relying on that to in your turnover order.
I think that it is, and I think that the ruling of the court, even though I know you don't have a record of it as of the time it was issued, but the record that was the order that was issued, the ruling that was issued at the time that the hearing occurred.
But, and I'm not fussing at you.
All right.
But ordinarily, when we have these situations, sometimes we will in a family law case, for example, where the judge will orally render the parties divorced. But my understanding has always been those are done on record. That way there's a reporter's record. The parties can go back and determine what the judge meant, and then simply signing the order was a Scrivener's Act consistent with what was going on here.
Correct.
If we don't have a record, we don't know whether there was any.
Well, the way you know is the order references the hearing that occurred. And that memorializes what the ruling was at that time. I mean, I understand the technical procedural issue you're raising, but I think that the memorialization, as it's stated in that order, of the event that occurred prior is referencing the action that occurred. And so that's the record that you have that you can look at to see when it occurred and what occurred, even though it wasn't till a later date that actually a document was signed. It still shows the action occurred and when it occurred, which is within that 10-day period.
Specifically as it regards the return order. Under what authority does the trial court have to order the return of property that is transferred in 2023 before the guardianship proceeding ever began.
There was evidence put on at the trial that showed that the.
That was that was the guardianship proceeding. We haven't had a trial yet on the, what I'm calling the adverse action or the action, the declaratory relief, the
Talking about the return of the equipment.
yes.
Okay, so that occurred.
So was it, what was the return order based on something? It's not based on the adverse action?
Return order was, you have the.
That was part of the guardianship?
Part that, well, let me just clarify if I can, just one second, something that was raised before, and I thought that there were some questions here. And we cited it in our briefing. But I'll refer the court to the Wood versus Dalhart case. It's 259 Southwest 3rd 229. Court has that in its briefing. And in that proceeding, which is from this court, issued by the Chief Justice, it provides in
That
here.
doesn't carry much weight. with
I
it.
know, I know.
Maybe that's why you got this panel.
Yeah, I know. Okay, I'm just going to read to you. And this is the law that he says, this is the law. Upon the filing of an application for the appointment of a guardian over a person or his estate, and until the guardianship is settled and closed, the administration of the estate is considered one proceeding for purposes of jurisdiction and as a proceeding in rem. Okay, that's what the statute also says that was cited there. So we're dealing with the property of the estate, and everything that's related to that is one proceeding. Then he goes on to say, where there is a county court of laws, in this case, all applications, petitions, motions regarding the guardianship shall be filed and heard in those courts. In this case, they're talking about the county court of law. Statutes also provide not only that the court exercise original probate jurisdiction, that a court exercising original probate jurisdiction has the power to hear all matters incident to the estate, but also that in proceedings before the constitutional county court and the county courts at law, the phrase incident to an estate includes a claim by or against a guardianship estate, all actions for trial of the right of property incident to the guardianship estate. So back to your question earlier about where should a matter be filed related to this property that was taken, when the evidence that was put on in the permanent guardianship hearing clearly established that the ward had moderate to severe dementia well before those transfers. He had that evidence before him. And so now the proceeding, which is before the trial court as we speak, to be able to go and to recover that property that is believed to be, based on the evidence that was presented, to be the property of the estate, has to be filed in the court that has the original jurisdiction.
But we don't. If the property transfers happen before the guardianship, we don't have a guardianship estate yet.
That is correct. But if that, so you have two different components, and that's true. You have the, what I'll call the July 16th transfers, which we're talking about a trust, and I'll get to that, which is different.
2024.
2024. And then we have the summer before,
Yes.
and we have July and October of 2023, prior to the guardianship being instituted. Okay. But the evidence that was put on at the time, it clearly established that the issues with the ward occurred and were occurring well before that. As a result of that, the guardian has the obligation to file an action to go and recover property. Even though it was before the guardianship happened, they have to go back and recover the property that was the ward's that was taken before the, the timing of the guardianship occurring. You have to go back. You can't just say, well, the guardianship occurred on December 23rd. So anything before that that was taken from the from the ward, we don't have a claim in. He has the guardian has the obligation to go back and to try and recover anything that was taken, because that's the reason you have a guardianship. The guardianship is put in place to protect and preserve the property and the assets, in this case, of the ward.
Well, isn't that what the action filed against Monty is designed to do? Is to invalidate those transfers?
Well, it's to undo those transfers
Undo.
and do both of them. Undo both.
Then why would you need both?
Well, we have to go back and get the property that was transferred prior to the guardianship, which is when this stuff all started happening. You're saying, what is going on here? I mean, if you didn't recognize and allow that, if somebody took advantage of a ward that didn't have the capability of making decisions, and as a result of that, when you find these things going out and you establish a guardianship, but you can't go back and rectify it, then there's really no value in the guardianship to be able to correct problems that ward has suffered that led to the need to have a guardianship put in place. So the evidence was clear before the court. And to answer Judge Dosh, your comment or question earlier, what is the standard of review? Standard of review is to, if there's any plausible basis to be able to support the trial court's findings, irrespective if this court disagrees or maybe comes up with a different answer, that is the view and that is the ruling that.
Well, I
Wait,
agree.
the
That's with
guardianship?
regard.
For the guardianship or for the adverse action?
The decision of the trial court in any of these actions.
My reading of the abuse of discretion standard is we look at questions that are disputed questions of fact, and certainly there's deference on questions of fact. But decisions of law are still de novo. There's no deference to the trial judge.
Correct. And so if there's facts that are there that support, based on a legal basis, the decision of the trial court, then those are decisions that this court would then recognize. But to sum that up real quick before I move on, any proceeding that's related to the guardianship estate and the ward's property must be brought in the court that has the original jurisdiction for that matter.
Right.
So you
I don't disagree with that. I just.
And so when the question was, do we go over here and have to file a separate suit against Monty as trustee? Absolutely not, because it's dealing with property that is clearly the ward's property that he contends he could go with during this guardianship hearing and transfer it the day before. And this isn't the standards. And I would refer the court to a case that is not in briefing that I've come
Let's
across.
say I followed your logic.
Okay.
And yes, we absolutely do need to have a procedure like this to protect the ward from somebody who takes advantage of them. And say in this case, we have Joe the Butcher, who took advantage of the ward and all the cattle was assigned to Joe the Butcher. You would need to bring in Joe the Butcher in that guardianship to get that property back, right?
If Joe the Butcher was the individual that did it, but if Joe the Butcher said, I'm going to put on another hat and call myself something else, even though I'm still Joe the Butcher, and try to hide behind this legal shield of I've manufactured this capacity that is not permitted under the law, which I've laid out in the briefing, and I'll point out a few things, then I bring in Joe the Butcher. Yeah, exactly. And that's what we did. But if Joe the Butcher tries to pretend to be somebody else, then, and that somebody else is not legally permissible, then by recognizing that Joe the Butcher is somebody else, is recognizing that he has done something that does not comply or comport with what the law allows. And so now we've just manufactured a second entity or identity that's not even in existence under the law.
Are you talking about why you didn't serve him or sue him as the trustee? You sued him individually? Is that what you're addressing?
Exactly. Yeah. I think that's what you're talking about.
It is. The trust is a separate entity.
How?
The trust is a separate entity if the trust is a valid instrument, but by law, it cannot be. And the cases that I've cited, and I'll point the court to, state that a ward does not have the ability, once there's an active proceeding, does not have the ability to convey property without the authority of the jurisdiction of the court that it's in, depending.
He's not a ward yet in 23, right? This is before.
Okay, if we're talking about that property, then we're talking about in the original proceeding when the guardian is appointed, and the guardian has the responsibility to go and try and make sure that the ward's estate, whether before they were appointed or after, is taken care of and protected.
I guess I understand your other argument on his role as the trustee. If you're saying he's ultra vires or he's acted outside of his authority, I can understand. We've got to tee that up. We've got to look at that issue, but it still seems like you've got to sue him in the correct capacity. Otherwise, there's never a due process opportunity for him to say, no, I did act in my proper.
Okay, and let's back up because we're kind of getting to
Sure.
the whole merits of the case. As we sit here today, that very issue is teed up in the trial court. We filed that petition, that pleading is pending right now, okay? That is, as the court, as you pointed out, is a matter that ultimately will be determined at a final trial. What we're here on today is, until that has occurred and we have the opportunity to do that, how do we protect the ward's estate so something doesn't happen between now and then to cause that to be irrelevant?
You've sued as a trustee and you get a TRO saying, don't turn anything over.
By doing that, my opinion is that I've recognized that he is a trustee, and I believe the law is very clear that he cannot be. He cannot, that the ward, this under provision, well, the Baldwin case, you cannot transfer property without the authority of the court. So if you have this guardianship in place and you take a ward who then signs and transfers all his property, doesn't matter if it's to a trust or to Joe Blow or whoever, if he transfers all his property without the consent and authority of the court that has the ability and is the requirement, the duty to authorize or not, and that is, if you'll look in the I said Baldwin, the Wood case, that was a will contest case, and what that case dealt with is whether or not there was authority to transfer by the ward this property. The ward transferred it, and in fact, you know what? In that case, they said this ward was sane when he did it. He knew what he was doing, but there was an active proceeding pending, and what that case held was, and just real quick, there were a transfer before by the ward, and then there was an application which complied with the statute requesting the court to give authority to transfer to someone else. So you had these two competing transfers that occurred. What the court held was, because there was an active guardianship proceeding pending, that the first one didn't comply with the statute to request the court's authority to do that, and that the ward did not have the authority on, regardless of what rights we've heard today, they should have rights, but did not have the authority to do that without the permission of the court. And so that transfer was negated, and the one that was proper, which was a request of the court, which was granted, was deemed to be the valid transfer. And so
What is your argument on that? Why he's not a valid trustee then?
because he went the day before, final day of the hearing, Monty did. He took his father, he orchestrated the signature of these documents.
Wait, I'm talking in 23.
In 23, because the evidence that was before the court, it's in the record, plethora of it, stated that he had severe, moderate to severe dementia well before that, and that he had these issues that he did not have the ability to make decisions, is what the record shows. And then we have the banker who came in and said, Mr. Hooper, had he known that Kenneth was in that condition, his testimony was in the record that he would not have allowed that transaction to happen. He would not, because he's the one that helped draft those documents. He's the one that helped facilitate that whole transfer with Monty, because Monty came to him. And so the evidence is
that testimony after the fact, like had he known at the time, so he knew otherwise at the time? I'm just trying to get it straight.
he didn't know, because it was all kind of manufactured by Monty, and he didn't know. And once he was aware of the evidence that was put on at trial that was shown to him, he said he would not have done that.
Would you agree with me, or would you agree with Ms. Block, that under section 1151.001, you don't currently have an order from a court that strips the ward of his power to dispose, manage, start a trust, et cetera? It seems like, according to the language, you have to have express language divesting the ward of those powers.
If you were required to say every single thing that was divested, but you couldn't include all of them. The language in there says that the guardian has the responsibility to manage, maintain, and protect the ward's estate. Well, that's to the exclusion of everything else. How can they maintain it if somebody else is taking that role. Let me just say, I've got 8 seconds here. If you look at paragraph 30 of the findings of facts and conclusions of law, it clearly states the court considered and found that Monty was not, it was not in the best interest of the ward for Monty to serve, which shows that the court took that into consideration. Out of time. Any
You
other
mentioned,
questions?
you mentioned a case you had not cited in your brief, and then we got off on something else. Do you have a
Yes.
case you
get
want
you
to
that
cite?
thing. It's a memorandum opinion. It's Dildine versus Bonham. Side is 2009 Westlaw 638200. That's the will contest case. And that's the case that provides that what the standard is for a trust. And that's not, we have this confusion about testamentary and a will, and we can go do all that. We're not talking about a will here. He's still with us. He hadn't deceased. So we're talking about what is the ability contractually to be able to enter into to that standard of agreement. And this case right here talks about that, talks about the sufficiency standard, about how you review that for the trial court.
Do you have any authority to support your position that if you want to bring a suit against somebody who purports to be a trustee but doesn't have authority as a trustee, you only need to name them in their individual capacity? Because doing so otherwise would waive your rights to claim they're not a trustee?
There's not, I didn't find any case law that one way or the other. But if a capacity doesn't exist as a matter of law, and if you look at the Baldwin case I referred to, which says you don't have the ability to transfer that. And if you go look at the statutes which require court approval to transfer property, then you take that for the guardian, not for third parties. But if a guardian has to get approval to transfer it, if a guardian is required and tasked with the responsibility of maintaining and protecting and preserving assets in the property of the ward, to think that a third party can go and orchestrate that to happen, and then to say through which the evidence clearly shows the undue diligence that, or excuse me, the undue influence that's put on a party, that just can't be allowed. Let me just say, if I can, just one thing. This started the court pointed out, in the county court. The answer that was received in the county court was not liked on this side. So what happened? They removed it to the county court of law.
Well,
Okay.
if that's mandatory when there is a contested guardianship.
Well, right, they came in because they didn't like the outcome, and they contested it, which I agree. Okay. But then what happened? Then they didn't like the outcome there. So they went to Floyd County, which is in the briefing, and they filed what you're talking about in Floyd County. So we've been through all the litigation in Floyd County, which the court sent it back down where it's supposed to be. Okay, where we had already filed and where it was pending the exact matter that Judge Parker's talked about. So we have all of that, and then they don't like the answer, so we're here. Okay, we're going from court to court to court. Every court has determined that based on the evidence, the decisions that are made are the decisions that are in the best interest of the ward and that are allowed under the law. As we sit here today, also, we are not here to have a final determination. We haven't had that hearing down there. This is a temporary injunction. The standard for temporary injunction is just that we had to have the ability to show that there was a claim, we have the likely probability of success, and that there's imminent harm if we didn't do that. That was established. If we prevail at final trial, that'll be determined. I think we will, but that is not the issue today. Did we meet the standard for a temporary injunction? And so with that, I would just ask the court to uphold the trial court's decisions, that the evidence is more than sufficient to show what is before this court to be able to support that. Thank you.
Are there any I guess the concept that the court would determine in a guardianship proceeding whether transfers of property that had occurred 6 months or so before the guardianship proceeding was even initiated, that the court would somehow render orders affecting that property.
No, my only response to that is the Wood case, where I think we've got some other side, but that's one that's clear, which provides that anything that is incident to the estate, okay? So if you have property that's incident to the estate,
Yeah, I
regardless
have
of
a
when,
problem with it after the guardianship is established and then having proceedings to determine what the guardianship estate should be. But reaching back and saying at that hearing, when you're determining whether someone should be under a guardianship, that we're going to go back and
Well,
scoop
okay, but
in all the transfers within a period of
in
time.
the chronology of the events here, the procedural history, the permanent guardianship, which is where a lot of this came out, once that was concluded, okay, then the guardian became aware of these things that happened. And it was after that guardianship was established that they then have to say, oh, somebody took advantage of them before.
Okay, so that was what the turnover order was about.
The turnover order dealt with the guardian being, which is totally separate. The turnover order is when the guardian's appointed, they had the responsibility of filing the inventory
Sure.
and letting the court know what's there. So the guardian made request of the person who had the inventory that the accountants had kept records of for years that were the ward's property, and said, turn this over. No response, no response, no response. So we said, oh, we need more time to file the inventory because we can't get the stuff to know what to complete in the inventory. So when that didn't happen after multiple attempts, the request was, Judge, can you help us out? Can you order that we can get that so we can comply with our statutory requirement to file the inventory so we can know what there is to file? That was all after to comply.
I misunderstood. I thought a while ago you said that the court heard evidence of that he was incapacitated.
That's talking about,
Dementia.
that's the 2023, October and July.
Yeah, that's what I was talking about.
Yeah, okay.
Yeah,
So-
that somehow, that was before the guardianship.
That
even
was, so that
initiated.
was before the guardianship. And that came about through the evidence in the permanent guardianship proceeding, okay? Once that permanent guardianship proceeding concluded, there was a appointment of the guardian for the estate with the knowledge that was acquired as a result of this process, that they became aware that these things had happened. And so because the evidence showed that this ward had a mental capacity based on the medical evidence that was subject to what we're claiming happened, that allows us to file the claim that we filed after the permanent guardianship was put in place, to be able to say, Judge, yeah, the guardianship happened here. You pointed it right here. That's the permanent guardianship. We have found out through this proceeding that things happened prior to that, which often does, because everything doesn't happen after you get the guardianship. Usually things happen that cause you to have to get the guardianship. And as a result of that, a proceeding related to that property, which is still before the court, and depending on how that goes, maybe we're back up here again or not, but we're going to have to go and have that hearing, have that trial.
Yeah, that's the guardian's original petition,
Correct.
requesting declaratory judgment.
Correct.
Restraining order.
Correct.
Rejected.
And that is what that proceeding right there is, what the temporary injunction is related to. Put things on hold. Let's make sure nothing happens, because if something happens to that land, we know under the law, land is unique. There's no adequate remedy at law.
What about cows selling?
Anything incident to can be, and I'll get you the case, can be brought into the temporary injunction for no adequate remedy at law. So that's all inclusive, because the main aspect is the real estate, which clearly is, there's no adequate remedy at law. So the things incident and related there too, for the operations of what the ward was engaged in.
What if the court or the fact finder ultimately determines that those prohibitions went too far and that the other side is now injured? What remedy do they have?
Good point. And let me go and clarify something I think that at least I have a different understanding of on the bond. The bond that's in place, the $1.5 million, is intended to protect one in the guardianship, the creditors of the guardian, of the ward. It's covering the same property, because the property that's covered in the guardianship is the same property that's now the subject of the temporary injunction. The irony of this, and think about this, the argument that I heard, at least in the briefing that wasn't talked about today very much, but the argument is there's problems with the bond, right? How can the bond cover both? Well, it's kind of talking out of both sides of your mouth a little bit. Their position really is there are no assets in the estate. We took them all. So there are no assets, so it's zero. So why would there even need to be a bond? Why would there need to be $1.5 million bond if they claim that they have it all and they own it all? That doesn't make sense. But there is a case, the Purdy case that they cite. That case doesn't even apply here. That's dealing with two separate matters where the court came in and said, there's a severance agreement over here. This bond that was used for that cannot, because there's two separate distinct matters, doesn't apply to a non-compete separate claim over here.
Okay, and that's in your brief.
Yes.
Okay.
But if it's covering the same property, the same matters, then based on that reading, it said they aren't opposed to that. But if it's two separate matters, you can't have one bond for two independent, completely distinct matters.
Well, and then we have the Rule 684, which requires bonds in.
And let me just say this too.
No, I think your time is up, and I think
They've waived that under this court's ruling. I'll just tell you that, because they cannot argue if they didn't object to that at the time that the ruling was made, then they are barred from being able to even raise that issue. So that issue can't even be before this court. But I don't think it's an issue, but I think that
is that one of our cases or a transfer case out of Austin?
no, that was
We're not, I don't think we're bound by.
well, no, it was this court here. And it was the what case was that? Yeah, the Rhodes McBee case.
I'm sorry, what was it?
The Rhodes McBee case,
What's the site?
2022 Westlaw 204-85142.
Does it say what the originating court was? An appeal out of,
Yeah, I'm just trying to 237. Thank you for your
Thank you.
indulgence, and
Excessively out of time.
I know.
it wasn't that bad. I had appeared in front of Chief Justice Wright one time and she had me up for 45 minutes. So you're going to be okay.
I'm just hoping my telepathy worked on all the other stuff.
Ms.
I might
Block, are
give
you
you-
still with us?
I'm sorry?
You're still with us?
Yes, I might give you some of my 5 minutes back, but I'm not going to make any promises. Let me start with the very last issue that the court addressed on the bond. This court has not definitively ruled yet whether the failure to set a bond is waivable. But I submit to you that that's not a procedural defect here. If the court had simply not set any bond at all, that would have been a procedural defect that in some courts would be waived. What we have is a very substantive defect because the court did set a bond.
Well, did he really? Because he just said, we're going to use the one in the guardianship.
And that was error to say the same bond can apply. My point is that the court did set a bond in the sense that the court said, I'm going to use the previously filed guardianship bond as the temporary injunction bond. That is a substantive defect, not a procedural
Does
defect.
the language of the bond identify who it's paid to?
Yes, the court. It's even by statute. It's payable to the court because the court has jurisdiction over the word's estate. So it certainly doesn't protect Monty in any way. And also on Mr. McCauley's point, he said that it's the same property. It's not. the glaring example is the more than 22,000 acre, I'm sorry, 2,200 acre ranch in Crosby County that Kenneth conveyed to Monty back in 2023. Was never part of the inventory. The value of that property, that is Monty's property. He's owned it since 2023. That's not part of the guardianship bond at all. And yet the temporary injunction enjoins him from doing anything, conducting any business, disturbing the status quo on property that he's owned since 2023. Mr. McCauley says, and I'm trying to quote as best I can, by law, the trust can't be valid, he says. He also says the law is clear that the ward can't transfer property without authority of the court. There's no case or statute that says that. Nothing requires the ward to get authority from the court. And that's, I keep talking about retained rights. By common law, and we have the two Supreme Court cases I've mentioned, Weatherly and the recent one in Ray Benavides, that talk about the importance of the word's retained rights. The whole point about retained rights is the ward had them to begin with. The ward retains them. So the ward doesn't need to go get court authority to dispose of his or her property. That right is retained unless it is stripped from the ward by specific court order granting that authority to the guardian. And the only case they have to cite is the Baldwin case. It's a very old case, very distinguishable. The court in that case notes the importance of the language of the relevant statutes. Of course, 100 years ago, the statutes were very different than they are now. That was a permanent guardianship, not the temporary guardianship that we had in place at the time of the July 16th conveyances. It was after a full trial on the merits. And also on that point, on the trial on the merits, we do have the judge, the trial court judge, issuing an amended temporary injunction. The only change was it added not a trial date, a hearing date on the permanent injunction sometime in August, but it doesn't set for trial on the merits the underlying claims of undue influence and fraudulent inducement. And we've made a jury demand, so we're entitled to a jury trial on those underlying causes of action. So back on this concept of retained rights, both the case law and the statutes talk about the importance of maintaining the ward's retained rights. You can only strip the ward of those rights by specific court order. Mr. McCauley suggested that it'd be near impossible to do that because the court order would be lengthy. It's not impossible to do it. You pull the statute, you look at the ward's retained Bill of Rights, and I can't remember how many provisions there are, but I don't think there's more than about 20. And the order could track that and say, this one's, yes, retained by the ward. This one, no, we're going to grant to the guardian. This right may be retained by the ward, but no, this other right we're going to grant to the guardian, thereby stripping that right from the ward. So we have common law, statutes, and the language of the temporary guardianship order, all supporting the argument that, well, the reality that Kenneth retained his personal rights to dispose of his property how he wanted.
Can I ask you a question?
That's why I'm here.
Trying to do a little statutory construction here. You look at section 1151.001. It says the guardian, so the incapacitated person for whom a guardian is appointed, so the ward, retains all legal and civil rights and powers except those designated by court order, etc.
Yep.
Then under 1151.351 B8, the ward is authorized to exercise full control of all aspects of life, not specifically granted by the court to the guardian.
Correct.
Is there a conflict in those two?
No, no, and they're consistent with the long history of common law we have in Texas of maintaining the dignity of the ward and the retaining the rights, the importance of retaining the rights of the ward. The court does have the authority upon the findings that are required for a guardianship. The court does have the authority to strip the ward of those rights by specifically granting them to the
And
guardian.
that, I guess that's ultimately what my question, it doesn't just have to say the ward shall not do X, Y, and Z. It could alternatively use it in positive terms to say the guardian has the power.
I see what you're getting at. Absolutely. And yes, so if you have an order that specifically grants a guardian certain rights that the ward otherwise would have retained under common law and under the statutes, then yeah, you can read that and say, this court order, by specifically granting these rights to the guardian, has effectively stripped the ward of those rights. We don't.
But doesn't that open up situations like what we have here where a guardian's appointed and then is going to try to go back and invalidate those actions taken by?
Well, and
ward.
Judge, we don't dispute that Ms. Howe had the right to file a lawsuit to try to invalidate the conveyances. I mean, people do that all the time. Her theory for undoing them is undue influence. That's what she alleged. But you can't get a temporary injunction without showing a probable right of recovery on that cause of action of undue influence. We don't have that here. She also was required to get a temporary injunction to show imminent irreparable harm. We don't have that here. And then on the return order, she has the right to try to seek prejudgment attachment, which is essentially what the order does. But to do that, you have to follow and meet the very, very strict requirements of the prejudgment attachment statute. It is an extraordinary remedy. Anything else?
Other question?
Well, I took a little more time too, so we're even.
Thank you very much.
Thank you.
The case is submitted. We appreciate you all coming up here to argue your case. Even though you went over time. Even though you went over time. So we'll be in recess for about 5 minutes before we take up the last case on this afternoon's docket.